The Court of Justice of the European Union makes significant contribution to developing our rights as citizens, because judgments of the Court of Justice is towards all, binding not only the member states to which it is addressed, in the case of enforcement action, for example, when the Commission takes the member state to court, but it's also binding on all other member states. Likewise, preliminary references are not only to benefit that particular case in that particular member state, but it also clarifies the law for everybody. And through preliminary references, the Court of Justice has developed a number of principles which I have mentioned before. For example, principle of direct effect, which allows individuals to rely on EU law directly and claim rights from the supranational level, and using these rights to the benefits in a particular case in front of the national court. Another very important principle developed by the Court of Justice is the principle of state liability in damages, when member states fail to respect EU law and, as a result, individuals suffer damages. European Union liability in damages has been there from the beginning, and it is enshrined in what is now Article 340 TFEU. And basically, it is when the acts of the EU causes damages to individuals, they may claim the damages from respective EU institutions. However, liability of the member states is not enshrined in the treaties, but it is developed by the Court of Justice through its seminal cases. The principle of state liability has been developed to cover the gaps left by direct effect, because not all provisions of EU law are capable of direct effect, meaning that not all EU law provisions may be relied upon by individuals in national courts. Obviously, there are conditions that need to be satisfied, and therefore, sometimes direct effect will not be possible. Therefore, member states' liability in damages seeks to cover that gap and to provide individuals with certain remedies. Frankovic versus Italy, it was a case initiated by claimants in Italy. They were ex-employees of a company which got bankrupt. And there was an EU law directive which required the member states to set up certain guarantee fund for the situations that Frankovic and his colleagues found themselves, so that in the case of insolvency, any unpaid salaries will be paid out of this guarantee fund. The problem in Frankovic was that Italy failed to implement the directive, so no guarantee fund was actually created. Directives are kind of a direction to the member states. You need to achieve this result, but how you achieve it is up to you. Directives need to be implemented in the national legal order to make them effective. And the fact that this directive has not been implemented made persons such as Frankovic, basically their rights were affected and they could not claim damages from their employer because the employer was insolvent. So they sought to claim damages from the state because it is state responsibility to implement EU law. In Frankovic case, the Court of Justice established this principle of state liability. So in situation when the member state fails to implement the directive, there will be liability for any damages caused by this lack of implementation. So although state liability is not found in the treaty, the Court of Justice created these principles by reading into the treaty and stating that the state liability is actually inherent in the system of the treaty. Since liability for union exists, there should also exist liability for the member states' failure to abide by EU law. In order to claim damages from the state, state liability envisages that there's certain conditions that need to be satisfied. In the first place, the directive should provide certain rights or grant certain rights to individuals. And in the case of Frankovic, that was the right to claim any unpaid salaries from this guarantee fund. The first requirement is that directive grants rights to individuals. Second requirement is that these rights are clearly identifiable. And in the case of Frankovic, the rights are clear. Frankovic and his colleagues had the right to claim unpaid salaries from this guarantee fund, which was never created because of the lack of member states' compliance with the directive. The third condition for state liability is that there needs to be a clear causal link, the link of cause and effect between the failure of the state to implement the directive and the actual damages suffered by individuals. So non-implementation of directive is placed squarely on the shoulders of the member states. Non-implementation of directive is a serious act, and therefore there is no need to further demonstrate that this act or omission is serious. But there are a number of questions which were left open by Frankovic. What happens if the directive is implemented but implemented incorrectly, or it's implemented late? Another question left open by Frankovic is what happens if the question is not about non-implementation of directive, but any other breach of EU law? Would there be liability as well in a similar way as in Frankovic? All these questions have been addressed by the Court of Justice in subsequent judgments. Brasserie de Pêcheurs and Factortum are the two judgments in which the Court of Justice clarified that breaches of EU law may also trigger liability in damages. I would mention Brasserie de Pêcheurs case because of its interesting merits. Basically, in Germany there was a beer purity law which required that a product, which is called beer, can only contain certain ingredients. And there was a French importer of beer from France who couldn't sell their products because they did not comply with this national law. So in effect, the question is, when national law breaches EU law and causing damages as a result, would there be liability? So in this beer purity case, the Court of Justice clarified that yes, if member state is liable for any damages caused as a result of breaches to EU law, then individuals would be able to claim damages from the state, but the breach needs to be sufficiently serious. And in the case of Brasserie de Pêcheurs, the breach was sufficiently serious. Of course, there are a number of factors which would indicate whether or not the breach is serious. Another factor would be the clarity of the rule breached. So, for example, if the EU law or any provision of law is ambiguous, it's not clear, it's not legally certain, so to speak, then the breach would not be sufficiently serious. So the claim in damages will be successful if individuals can demonstrate that the law which was infringed by the member state intended to confer rights on individuals and that the breach is sufficiently serious. The principle of state liability provides individuals with strong tools to enforce their EU-derived rights before national courts against the state. And for this principle, we need to thank the Court of Justice and its judicial creativity. Thank you.